this is Jeff Fowler with the Apartment Owners Association, and again, it's great to have you with us today. And you're watching this because it is complicated, so complicated, and so many landmines trying to evict somebody who hasn't paid the rent. Such a simple, straightforward thing you would think, but that's not how it is here in California. So we're here today to help you understand what some of those landmines are and help you win that case. And before we get started, thank you for being an AOA member. I know many of you are. If you're not, it's $97 a year. There's no per unit charge on it, and you get access to our staff where you can ask questions, property management questions, full access to all the forms. You have access to low-cost tenant screening reports and really so much more. And I know that sounds really cheesy coming out of my mouth, but it's really the truth. We do have rent reporting. So if your building is 16 units or more, I believe, maybe it's 15, then you're required to offer rent reporting. We have a form for that, but we also have the service itself. It gets reported to TransUnion, and you can sign up for that. It's called White Glove Rent Reporting. It's $5 per renter per unit. Per renter, but it's really for their entire unit. It's just $5, and so as many people that are in there, we're only going to charge you $5. And anyway, so that's something, a resource for you. We want you to stay compliant.
Jeff, is your speaker? Is your audio on?
Is it not working?
No. Oh, I know why. Jeff.
Oh, fella. Go up high. One more time. So start over, right?
Yeah.
Hi, this is Jeff Fowler with the Apartment Owners Association, and it's great to have you with us today. And we're just so honored to address a group of people that is as successful as you are. You've made a great decision to own rental property, and I know that it seems like it should be very straightforward to evict someone who hasn't paid the rent, and unfortunately it's not. There's tons of landmines, and today we're going to cover how you can win your eviction case. Before we get into it, we are really dedicated to your real estate success. We want to give you the information that you need to be able to do that. And if you're not a member with us, it's $97 a year, that's it, and there's no per unit fee, and you have total access, 100% access to all of the forms that we have, and you can call in whenever you need to get property management advice. And anyway, there's a whole lot more there. And one other thing I do want to highlight specifically is that we offer rent reporting. This is something that we do directly, and we report to TransUnion. It's called White Glove Rent Reporting, and you can call in, ask about that, and we can get you set up and report the renters that opt in. And that is a reward for those that are paying the rent on time. It helps them build their credit. So of all the negative things, there's something positive. Excuse me, a way that you can help them. And if you own a building that has 15 units or more, then you actually need to do it. And we lost the signal there on the other thing, but hopefully we're good. Great, there it is. And so that's there. And then one other thing I want to mention, I just read this morning, that Gen Z, 77% of them would prefer to fill out a rental application online. And that is possible through our software. And it's the AOA rental application and all those things, and the disclosure that you need to have to be compliant here in California. However, you can customize it to a great degree, which is really cool. And so just want to mention that. And you may have missed some of the last things that we've done. We had an AOA membership orientation. You can find that on our YouTube channel, AOA USA. And we covered tenant buyout agreements. Next week, we're going to cover the balcony inspections and the deadline that's coming up on that. And on the 23rd, so not next Thursday, but the following Thursday, we're going to be going over is if rent control is a takings or not, according to the Fifth Amendment. And I get calls all the time, and I agree with you. It seems like a total violation of our rights, as our property rights. And so we're going to have an attorney on who will address that. So you may want to tune in for that one. And in person, yeah, there's a lot of stuff going on. In person on the 21st in Sherman Oaks, we're going to cover how to avoid procedural mistakes in eviction actions. Buena Park, security deposit, essential things that you need to know about that we'll cover. And then in Fremont and Santa Clara on the 28th and the 29th, we'll cover those procedural mistakes in eviction actions. So all those are in person. They're great for just meeting other owners and connecting and getting questions answered. We try to answer questions here. Sometimes there's not enough time to get to everybody's question. And anyway, so those are some opportunities that you have. Because you're a member, it's free. It's free for you to attend those. And so just want you to be aware of that. So here we go. Our speaker today, I want you to get ready to hear from one of California's top legal fighters in the landlord-tenant space. He is a managing partner for California Property Law Group and a seasoned litigator with a winning track record in unlawful detainer cases. He's a proud graduate of UC Santa Barbara and New York's law school. He's known for a strategic courtroom style, relentless advocacy, and proven results against tough opponents. And I'll tell you, there's a lot of tough opponents out there right now. We're excited to have him share his insight and expertise with us today. So please join me in welcoming Rafael Azizyan.
Yes. Hello, everyone. Thank you, Jeff, so much for having me here today. Again, my name is Rafael Azizyan. I'm a managing partner at California Property Law Group. In my office, we specialize in unlawful detainers, also known as evictions. That's the only thing we do. And when I was asked to think of a topic for my presentation, I thought, well, due to my trial attorney background, what better topic than how to win your eviction case? Because I've been in court many times, and sometimes when I'm reading the file, there's so many things that make me sweat when I find out my client didn't do something that they should have done, or notice wasn't given. So I wanted to take this opportunity to talk to you a little bit about the many ways you can lose your eviction case. But if you know ahead of time, there's absolutely no reason to lose. So, and before I start, a lot of times, really, as a landlord, it's not that you have a bad case, it's that there's so many requirements that you need to comply with, both state and city, that they want you to comply with. So if we're able to take care of many of these issues beforehand, then your attorney can actually have a shot at winning your case instead of losing on a silly technicality and having to restart all over again. So I'll jump right into it. I wanted to start with this slide from Sun Tzu, which kind of coincides exactly with what we're doing here today. It says, victorious warriors win first and then go to war, while defeated warriors go to war first and then seek to win. So what that means is, what I want to do is I want all of us to basically, before we start our case and get into litigation, which is a form of war, we want to be able to do all our homework so we could actually have a shot at winning. So, and if you've ever gone through an eviction before, you know that there's this doctrine called the strict compliance doctrine, and there's no wiggle room for error there. If you don't comply with most of the rules that we're about to talk about today, then you will lose your eviction case. So the way I organized this lecture or this presentation was I wanted to divide it into 5 sections. So there's 5 responsibilities as a landlord that I want you to be aware of. There's going to be registration requirements. That's the first one we're going to talk about. And the second one is going to be notices that you need to give to your tenants. The third topic is going to be notices that must be posted on the property. The fourth topic will be rental agreement requirements, laws or notices that need to be included in the lease. And lastly, your conduct during the tenancy. So let's begin. So the first thing is registrations. So there are some cities in LA County in Southern California that require you to register your property. So this is the first step. So if you have a property, you have to make sure that you register. And that little graphic is my take on the city asking you to pay them their money. So LA City, both for RSO units and for non-RSO units, you have to register the property, pay the fee, and send a notice to your tenant in the mail that you registered your property. That's a must. And you will. This is most of the things I'm going to talk about today. If you don't do that, you will lose your case. So LA County unincorporated, if your property is located somewhere in an unincorporated part of town, you want to make sure that you also register with LADCBA. Santa Monica has a registration requirement, West Hollywood. Though Lancaster does not have a registration per se, it's more you have to be registered to do business in Lancaster. A lot of people don't know that. So you need to make sure you get that. And some of these registrations, although you're not required to post it on the property, it would be helpful. A lot of them, like for example, LA City and LA County, they want you to send it to the tenant as well. As soon as you get that statement of registration, it'll have a year on the top right. It'll say 2025, 2024. It'll tell you how long it's active for. You want to just make sure you go ahead and put that in the mail and send it to your tenant. So that's the requirements, number one, that we want to make sure that we register our property. So the second topic is notices to tenants. So it starts very, very early. So I can't tell you how often a case will come into my office and I'll find out that a new landlord purchased a property from a prior owner and they forgot to give a change of ownership notice. And a change of ownership notice doesn't just mean, hey, I'm the new owner, this is where you can send my rent. That's what majority of people do. A change of ownership notice has to comply with Civil Code 1962, which has specific requirements about what needs to be included in that. For example, an address where payment can be made, a place where you could be served documents, what form of rent you accept, for example, check or electronic. So I believe AOA may have a form on their website. You can use that. If you can find that in my office, my law firm website also has a form you could download for free. You can go to capropertylawgroup.com and download it. There's a lot of these available online. So you want to make sure that when you purchase a property, the first thing, it starts very, very early, you must give the 1962 notice to your tenant. Otherwise, you're not allowed to collect rent until you do. So if we start an eviction case for non-payment of rent, and then during discovery, during litigation, when opposing side propounds discovery on us to find out information about the case, if they find out that something like as silly as a little notice that wasn't given 4 years ago, it wasn't given 4 years ago when you purchased a property, believe it or not, you could lose your case. So we want to make sure that we do that. The next notice that's really important is the right to counsel notice. And this one might be the most important of them all. The reason is because if you don't comply with it, you could be subject to attorney's fees. When you're in court and you lose because of that, then the prevailing party, which will be the tenant, is entitled to attorney's fees. So LA City and LA County unincorporated both have a right to counsel program, and they want you to both post it on the property and also give it to your tenant when you're serving a 3-day notice to pay rent or quit, or any kind of notice for eviction. So you want to make sure you go ahead and do that. The RSO statement of registration is the it's when you pay your fee, the city will send you a statement of registration. It'll have, and this is for LA City properties. It'll have a little year on the top right corner. It'll say 2025, 2024. If you paid it this year, it'll be 2025. They want you to go ahead and send that to your tenant in the mail. And if you want a little bit of extra credit, you could just also post it on the property. It won't hurt. And just take a photograph that you did that. It's one of the ways that opposing counsel try to win a case on a technicality by going through a list of things that need to be posted on the property or given to the tenant and asking their client if, was this done, right? So if you want to, even though it's required for you to post it, it'll really help to strengthen your credibility in court to show that not only did you send it in the mail, you also posted it on the property. So, those are some of the things that. Lease renewals. So lease renewals are important for properties in Glendale, and if you have a property in Glendale that's subject to Glendale RSO, if you do a rent increase notice, you have to remember to give your tenant a lease renewal. So a lot of times people forget to do this, and you will lose your case in Glendale City if you don't do that. And also, I believe it's 60 days before a contract is about to expire in the city of Glendale. You also have to offer them an opportunity to re-sign the new lease. So just have that in the back of your mind that in Glendale, whenever you do a rent increase notice, that you must also give them an opportunity to sign a new lease for another year, for example. So the third part of our conversation today, I want to talk about notices that must be posted on the property. So the right to counsel notice we talked about a little bit before. It's the little graphic here on the left. It's attention tenants notice of right to counsel RTC. So this not only must it be given to the tenants, like I talked about previously, but it also must be posted on the property. So on the right, you'll see 3 notices, right? And if you have a property in the city of LA, there must be a part of your lobby or somewhere that's common for everybody that has these 3 notices. And it would be really helpful if you have a photograph of that. So the top right is the City of LA Renters Protections Notice, and the middle left is the Right to Counsel Program Notice, and the red and yellow Spanish notice, that's the notice to tenants that the property is subject to RSO, the Rent Stabilization Ordinance. So if your property is not subject to RSO, you don't have to post that red and yellow. But the other 2 notices must be posted for all properties. So for RSO, you just have to add that little extra red and yellow notice. I can't tell you how often this is not done, or if it was done, there's no evidence of it. And it is such an easy and silly way to lose a case. And I can't tell you how many times we had to settle on terms that we could have settled for better terms or not have to restart a case if this was done. And you don't really want to rely on your lawyer because, sure, you can always, it's expected that, you pay the money to your lawyer, then they're supposed to catch all these. But as you can tell, we're about to have a 4-minute conversation. There is so much that you have to do that it's almost impossible to get all that done during an initial intake conversation. So you want to be able to proactively do these requirements, post them, send them to the tenants, so that when your case does end up with an attorney, then we actually have a really, really good chance at prevailing in court. So these are really important, and just make sure you go ahead and post them on the property. So not only are there notices that you must give to your tenants, and also notices that must be posted on the property itself. For certain cities, there must be requirements that's also in the lease itself that you must do. For example, the AB 1482 exemption language. So if your property is located in a city that does not have its own rent control, for example, Burbank, or let's say Palmdale, right? These are cities that don't have their own local rent control. So a lot of times you would be subject to the statewide rent control. So that, if you are a property owner that, if you own your property in your personal name, and it's a single family home, then you might be able to do a no-fault eviction. So if you have a single family home in Burbank, for example, right? Burbank does not have its own rent control. So you would be subject to statewide rent control, if any. So what you want to have language in the lease that says your property is exempt. The reason for this is one of the few places in Southern California that you could actually do a no-fault eviction for a single family home. And a lot of times clients will come to me and they want to evict a tenant to sell their property, and the tenant is current on rent, and they're not a trouble tenant at all, so there's no nuisance issue. And the landlord finds out that they can't really do the eviction because they didn't insert the AB 1482 exemption in the lease. So you want to be able to do that so you could at least preserve that right. Also, not only for eviction purposes, you also will not be able to raise rents more than 10%. So you want to have that exemption language in there if it's a single family home or a condo or a townhouse. And if you don't know, you could always email my office and ask, is my property exempt from statewide rent control? I could gladly answer that for you. So the no arbitration clause, this is actually super rare, and also this is probably the only thing that I'm talking about that you, technically speaking, will not lose a case over, but it is so consequential that if it does happen, that I wanted to bring this to your attention. For whatever reason, a while back, there was a trend to include arbitration clauses for unlawful detainers in the lease itself. That is awful. So if your lease has an arbitration clause for UDs, unlawful detainers, you want to take that provision out, because unlawful detainers get special treatment in court. You're able to have an expedited trial process. You file a case, and usually you'll have a trial date very, very soon. So you want to have access to the courts. You want to have access to the summary proceedings that are given to landlords. If you have an arbitration clause in there, to evict your tenant, you're going to have to choose an arbitrator, pay them money, and have to go through their schedule, which takes months, right? So you definitely don't want to have that provision in your lease. I think the lease that I see most common is the California Association of Realtors lease. They don't have that in there. I'm talking about, usually you want to be on the lookout for leases that is not from a reputable company, and just go to the last couple pages. Usually that's where it's hidden. Make sure that there's no arbitration clause in there. And if it is, before you start your eviction case, you want to flag that to your attorney's attention, because a lot of times, because it's such an unusual part of the lease, that you don't really find out about it until you're in the middle of a case, and when you do, that's not the time you want to learn about that. So don't have an arbitration clause in there for unlawful detainers, and you want to be able to go to court and have an expedited trial process. And the last couple two, so the RSO attorney fees for RSO units. So this, I guess, is the other thing that you, technically speaking, you won't lose your case. There's two of them. So you won't lose your case for capping attorney fees at 1,000, 2,000, or unlimited. But for RSO units, it's important to, in my opinion, cap it at $500. The reason with that line of thinking is I think that it incentivizes attorneys to take cases and over-litigate them. For example, let's say an experienced attorney, tenant's defense attorney, gets a notice and they review it and they see that this right to counsel notice is not attached on the notice. So he or she will know immediately that they're going to prevail on the case. So what I've seen happen a lot is they'll over-litigate the case because they know as soon as they raise this issue in front of a judge, that the judge will have to grant their motion for judgment on the pleadings. So because they know that, what they do is they'll over-litigate the case. They'll propound discovery, they'll do a deposition, they'll file motions, all just to build time. And then when they're ready to do so, they'll file a motion with the court telling the judge, Your Honor, the plaintiff, the landlord, didn't attach the right to counsel notice, for example, so therefore they need to lose the case, and the judge will have to grant that. And then you'll get a fat attorney fee motion at the end. And you don't want to get one of those. And also, a lot of times for your non-paying tenant, if you do end up winning, even if you do everything correctly, it doesn't really benefit you because a lot of times they're not collectible. So I think given the risk, it's probably best to just cap it at $500. And this has been the trend for a long time anyway. So it's rare that I see an unlimited attorney fee provision, but it does come up still very frequently. And I'd rather, whenever you're doing a lease for RSO units, to just not have that in there. And the reason I'm specifying RSO units is, I personally, if it was my own property, I would still keep it at $500 for non-RSO units as well. But sometimes for higher end residential properties, if the rent is more than $3,000, $4,000, $5,000, then those tenants tend to be collectible. So it might make sense for you to have that in there because it just keeps both parties in check a little bit. So a little bit of dealer's choice on that one. But I think that for RSO units, especially, you should cap it at $500. The next thing I want to talk about was foreign language leases. This does come up very frequently. So sometimes what will happen is you will negotiate the lease in Spanish or another language. You want to be able to give them a copy of the lease in that language. So if your tenant speaks Spanish, for example, you want to be able to get a copy of that same English lease in Spanish. And the reason is that if you want to do an eviction, for example, for a breach of contract, if they don't have a Spanish copy of that, then you can't really do it. So just remember, if you negotiate the lease in Spanish, you want to give a copy of it to your tenant or any other foreign language. So those are requirements that must be in the lease. Just remember them. And the last thing I want to talk about, your conduct during the tenancy. And basically, this is your, as a landlord, how you should approach your relationship with your tenant. So one of the things and this is the most common way you can lose your eviction case, is rent increases. So what I see happening a lot is landlords now generally have an idea about how much you raise your rent. It's common knowledge. What I see people making a mistake is they will send it by mail and the notice will say 30 days. You want to add 5 days for mailing. So it's such a really silly way to have an otherwise valid rent increase, and then it ends up being not valid because, yeah, you got the amount correct, but you didn't add 5 days for mailing. So that happens a lot, and I think for most attorneys that will agree on this issue, if you have a non-payment of rent case, the most common way you will lose it is if there was an improper rent increase done 5-6 years ago, which made all the subsequent rent increases invalid. So this comes up during discovery, and it's almost impossible to have it be brought up during your intake process with your lawyer, because when you're starting a case, it doesn't really, you're not sitting there for an hour and a half with your lawyer trying to see if you did everything correctly, right? This comes up almost always during litigation when opposing side will propound discovery, and you will go and find all the rent increases that you did and then give it to the other side, and they'll see that, wow, in 2015 you gave a rent increase and you didn't add 5 days for mailing. Well, you're done. So then you would have to restart your case. So for rent increases, you want to make sure that, one, you get the amount correct, and for that you could, does AOA offer that service where you could ask them how much to increase their rent? Or
We don't give them, we don't tell them. We tell them the percentage, but we don't tell them what
the number is.
Calculate,
Got it. So in my office, you could always email us, and I will tell you how much you could raise rent for your particular property. No problem. In fact, I think we have a section on our website where you can go and for majority of the cities in LA County, we have an up-to-date info on how much you could raise your rent in that particular city. So get the amount correct. That's very important. And then second, if you're going to serve it in person, it's okay to say 30 days. However, most of the time you're putting it in the mail, or you can't locate your tenant. You want to add 5 days for mailing, so it should say 35-day notice. And by the way, posting it on the door is not personal service. Personal service is literally you handing it to your tenant, okay? So 35 days, remember. Tenant anti-harassment ordinance. So in LA City and LA County unincorporated, there are rules about how a landlord's supposed to, I guess, conduct themselves during the tenancy, right? So they have a whole list of things that you're not supposed to do that they deem to be harassment. The most common one that I've seen be used in court is not doing necessary repairs in a fast and reasonable way. So if a tenant has, for example, said, I have a leaky sink and it's been 4 months, and no one sent to investigate, the city could deem it as, according to the tenant anti-harassment ordinance, it could be seen as harassment. So it's like if you prevail on one of the defenses of, let's say, breaching the warranty of habitability, then they have another way they can prevail by just arguing that it was harassment instead of breach of the warranty of habitability. So it's like another layer of protection given to tenants if the landlord quote unquote misbehaving, right? So, and another common one I see get brought up is coercing, or they use the word coercing the tenants with money to move. So going up to them saying like, hey, I'll give you $10,000, $20,000 if you just move, and they say no, and you again approach them another time and text them saying, can you move? I'll give you money. They don't want you doing that. So beware that there's a tenant anti-harassment ordinance. It's actually well written, very easy to understand. It just lists conduct. So all you do is just put on Google, if you're interested on what that conduct is, you can just go to Google and type in LA City anti-harassment ordinance, and you can read the law. It's like, I think 14 or 15 items that they list that you're not supposed to do. It's not particularly fun read, but it's important. And the next thing I want to talk about is interest. So for RSO units, particularly in LA, you're supposed to give your tenant annual security deposit interest. There's a formula that they have on their website, the housing department's website, that they want you to use. And what you want to do is you want to give them annual credit. If you don't give it, the end of the world, it just has to be done before the unlawful detainer case started. But obviously, it's good practice to do it yearly. So in case you forget to bring that to your attorney's attention, then you won't lose for just giving for a couple dollars. Like that's what it comes down to. So a lot of times, what we'll do is we'll have it be a credit on the 3-day notice. So we'll deduct it and give it while we're serving the 3-day notice. That's one way you can do that. But I think better practice is just to annually calculate the amount. It's only a few dollars. Just give it to your tenant. Then you don't have to worry about it. I know this law has been around for a really long time, but it really only started to be enforced in court, I think, about a year and a half ago. Before then, no one was really raising this, bring this to the attention of the judges. But one day, someone made the argument, it was granted, and then it just became, now it's like a thing. Now you have to do that, okay? So give security deposit interest. Or if you don't, make sure you raise that, bring that to the attention of the attorney. The last thing is repair records. So you want to be able to keep a record of all the repairs that was done on the property. Have a nice little file where if a plumber was sent there or an electrician was sent there, and then just put a little note on like how many days it took until when the tenant notified you and when you addressed the issue. So it's important because a lot of times when the other side is talking to their client about repairs, they don't really care about whether or not it was done. They're still going to bring it up to try to sway a jury or a judge that, oh, the landlord's a slumlord or the property is in horrible condition, and then they leave out the part that it was actually fixed. Happens all the time. So you want to have those records. So when they do make that argument, and they will, you want to be able to rebut that argument by showing your receipts, your well-kept repair records, and if we need to subpoena the plumber or electrician come testify that the work was actually done. So keep a nice file for each tenant. That's just really good practice. And those are the main 4 issues about conduct during the tenancy. So as far as final thoughts go, so I know that was a lot of information, but the point of this was not for you to just remember every single item that I mentioned, because you have to do this every day for it to really for you to really get it, right? And what I would like you to take away from this is just know what you don't know. So for example, like you should now remember that if you have a property in Glendale and you give a rent increase, then that'll now you'll remember this, and you would want to go research, like, what am I supposed to do, by the way, if I have a property in Glendale that I give a rent increase for? I think there was something I need to do. Or, oh, I have a property in LA. I think I need to perhaps post some notices in the common areas. So as long as you remember that, then you'll get a lot of this housekeeping done before you start your case. So just remember that there's a lot of requirements, and you want to make sure that you comply with them. And I can't tell you how amazing it is when we get a contested case and we're reviewing the file, we're about to go to trial, and I see that opposing side really doesn't have ammunition. They have nothing because you did everything correctly. And if that's the case, then you're either going to position yourself to win your trial or get a really, really fantastic settlement offer and not have to spend any more money on lawyer fees. So that's why it's important, because most of the time, the landlord didn't really do anything wrong. It's your tenant that didn't pay their rent. So as long as you take care of all these notices and behave the way that the city wants you to behave, include the right language in the lease, you're really positioning yourself to win your case. Thank you so much. And that's my 2 wonderful partners, Zach and Kenny. If you have any questions, you could always reach out to me by email, Rafael@capropertylawgroup.com, or you can give us a call.
All right.
Yeah.
Thank you so much for sharing.
Of course.
And we're going to go ahead and take some questions now. And in the chat here, I see Alan has a question about Civil Code 1962. Is that for tenants in all cities? Is that a California civil code?
Yes, that's a California Civil Code. Fantastic question. I know a lot of these notices that we talked about today was for some cities you have to do it, for some you don't. But the 1962 notice for all the properties in California, you have to do that. If there's change of ownership, you want to give a 1962 notice. Also, it is not just from another owner to the new owner. It's anytime the property changes ownership. For example, from LLC to a trust to an individual to LLC, even if you're still the owner, per se, you still want to be able to give that notice. So I had a case come up very recently where it was taken out from a trust into an individual and they didn't give the notice. Big no-no. You want to do that for every property. Anytime a property changes ownership in California, you want to give a 1962 notice.
Great. Angela, RSO is City of LA, not unincorporated, correct? And for unincorporated LA, do we post the other two notices, and can we get the slides?
Sorry, what?
So are you able to, do you want to give us the slides? Do you want, and then they get it from us, or do you want to have people contact you to get the slides?
Oh, the slides for his presentation?
Yeah.
Oh, either way, I'm totally fine with you.
Yeah, give him a, you see the email there at the bottom. It says info, capropertylawgroup.com. So you can you can email that and they can get it over to you, or give them a call. So that's how you can get the slides. And then for the question about LA, the RSO, is that just the City of LA, or is it LA unincorporated?
For RSO, I'm talking about the rent stabilization ordinance of LA. So it's not unincorporated. Unincorporated has its own rent control. When I say RSO, I'm strictly talking about City of LA rent control.
And then the question there is, for LA unincorporated, which notices do they post?
For LA City unincorporated, you still want to put the notice that your property is registered with LADCBA. And also, they have their own right to counsel form that needs to be posted. It's not the same one that I showed on my slides here, but LA City unincorporated has its own right to counsel notice. They were actually the first ones to do it. So they have their own. It's available on their website. That needs to be posted on a conspicuous place on the property, and also when you serve the 3-day notice as well.
All right, Kevin is asking, does AOA have the Spanish lease? And we do not. We encourage people to do everything in English, just because, let's say you speak English, but maybe, I'm sorry, excuse me, you may speak a foreign language, but how good is your son or daughter, next generation, when you're gone and everything needs to continue to be done in a foreign language, may not be there, or if the property management company that's taking over may not be. It may take a lot more resources. So we kind of suggest that people do things in English, just to keep it simple and straightforward. And then your question there, RSO, LA City duplex, non-payment of rent is under threshold. Should we still give a notice?
If you're talking about the 3-day notice to pay rent or quit, if you're under the threshold, I would just wait until they're above the threshold, because it doesn't really serve a purpose. The city's very clear. They don't want you to evict your tenant if they're below the threshold. So that notice itself, we're not going to be able to use anyway. So I would say don't serve it. Just wait until they're above the threshold.
All right. Great question. Anderson Ballard Companies. Is there a way to minimize the chance of tenants filing additional motions, such as demur motion to quash or request for jury trials?
Unfortunately, no, especially the jury trials. So the jury trials is a constitutional right. Everyone has that. If they want a jury trial, they get a jury trial. As far as the demurs, technically speaking, if you do everything correctly, then there's nothing to demur on. But what's happened, the trend in LA is, pretty much everywhere in Southern California, is the demurs and motion and quashes, they're not really substantive. They just find a form on the internet and file it in bad faith, it's just to delay it. It's not that you did something incorrectly, which is what a demur is designed to do. It's just that they get the form and then file it because it adds a few weeks to the eviction process. And a lot of times it's done as a pro per, a self-represented party. So because they're self-represented, judges are kind of not going to really punish them for that. If an attorney is filing baseless motions, then you also have the right to seek sanctions. But even then, I've really never seen a judge enforce sanctions against improperly filed motions. So I'm going to say, unfortunately, those are really annoying and they do run up your fees. There's really not much you can do there.
All right, Erica, do notices have to be sent by mail, or is email acceptable?
Email is never acceptable for anything that the city is requiring you, city or state is requiring you to do. Personal is almost always going to be just fine. If you cannot do personal, you want to add 5 days for mailing and just put it in the mail. Yeah.
All right, thanks, Erica. Keith, do you have, how do you respond when opposing counsel serves a mound of last-minute, unnecessary, and harassing discovery requests?
We would have to answer them. If it's completely last minute, we would object because discovery needs to be completed 5 days before trial. So assuming it's timely, then you have to unfortunately answer them. That's just part of litigation. We could also propound back to be just as annoying. And also, if you really can't answer it in time, you could ask for an extension. Usually they grant it. Almost always they will grant you an extension, but they will probably ask you to continue the trial, but you can get an extension.
Not that you want an extension. You want to get this thing over with.
Yeah.
You know.
Yeah, you want to answer in good faith and just be done with it.
Right.
For
All
sure.
right. Peter, my single-family property is in Moreno Valley. Do I need to also check County of Riverside renter laws that I need to follow, as well as city and state?
General rule is you find out where your property is located, the exact city, right? And you find out if your city has its own local rent control, okay? If it does, usually those laws will apply. And then you go, if the answer to that first question is my city does not have local rent control, then you move on to what the state wants you to do. So I'm not sure.
Yeah, for Riverside County, I don't think there's anything special.
Yeah, that's what I don't remember any rent control laws in City of Riverside or County of Riverside. So you want to just always keep in mind about the statewide rent control, AB 1482.
All right, Kevin. RSO LA City, cash for keys. Is there a minimum amount required, or is it purely negotiable?
Great question. I was thinking about this the other day. For cash for keys and RSO, for an RSO unit, there is requirements that you have to follow. You have to give them a renter's protection notice and then also file it with the city. And when you give the renter's protection notice, it states on there what they're entitled to for like if you have minor children, if you're disabled, or if you're elderly. And I think it's going to be very difficult for you to give them anything less than that. So I would say, even though it's negotiable, backtrack. I'm going to say I don't know on this one yet, even though we were talking about it. But you could reach out to me and I'll research that issue. What you want to do is you want to be able to negotiate at the very least the minimum amount they're entitled to, so that way you're going to comply with the law. As far as whether or not you could give them less than they're entitled to, that I need to look up. Sorry about that. I don't have it off the top of my head.
I don't think you can give them less than what they're entitled to. I don't think so. But all right. Okay, the next one, Larry. Would it be considered harassment if I post a cash for keys by the mailbox? Contact management to see if you qualify.
Huh. Interesting. Very creative. I don't think so. I'm going to say no because it's general. It's for everybody. It's like if they don't want to contact you, they don't have to. I don't think that's what they're really trying to prohibit. So I'm going to say no.
And then if it's a direct one, is it every 6 months that you have the opportunity to offer that, or how does that work? The cash for keys offer. If you offer it too much, it's considered harassment.
Right.
So what's the?
I wouldn't really offer them cash for keys directly. I just would try to. This is the kind of stuff that you kind of want to before you do it. You want to talk to a lawyer about, because there's that whole law that you have to worry about, right? So you want to make sure you're not. Yeah.
You definitely don't want to do cash for keys on your own. Definitely use a lawyer. I like what you said. You said, do not rely on your lawyer.
Yeah.
And I thought that was really good because you take everything in here, write down the action step that you need to take and get the things done, continue to be a student, understand what you need to do, because they might miss something and then you're really mad at them, but just try to be as proactive as possible. So that fact that that came out of an attorney's mouth was interesting to me. It made me smile, but it's really true. It's your business, and take ownership as much as you can. And there are a million landmines out there. We're trying to help you, and I love how you organized everything there. So great job. Thank you so much, Rafael,
Thank you for having me.
For putting that together. And hopefully you have an action point, or even better, hopefully you were able to check off on all those things. And I do want to say on how you're conducting yourself during the tenancy with those repairs, we do have the property management software that has a work order system, and then that's a log that can be printed out. So you want to document everything. The software makes it a little easier, if not ours, different software. Anyway, so I hope this was helpful, and we'll be back next week with more information for you. And again, we're in your corner. Oh yes, and I will say that there are several different political action campaigns that we have running right now. So if you go to aoausa.com, there's the PAC little ad. You can click on that. It'll take you to the PAC page, and I think we have 3 different campaigns right now that are listed. And if you get the word in on that, if you're able to send, it's all set up with software where basically we have a letter written for you that you can edit if you don't like what we write, but it will send it to whoever it is that it needs to go to. And there's definitely one for LA County right now. Anyway, so we really need your participation in it, because if it's just AOA as an organization speaking and our members aren't behind us speaking, then our voice becomes pretty weak. And so just ask you to let's all work together on all of these things and do the best that we can. And hey, we won. We did win Prop 33. There's been some other wins as well. And when we get involved, when everybody does get involved, I know it takes a few minutes, then we do win. And it's just so essential for this business. You're in business, you've got to protect your business and by protecting your property rights. Anyway, thanks again, everyone. We'll see you next week.
Thank you.
All
It's
right.
fun.
Thank you.
Are we still live?
No.
Oh, we're done. Okay,
Yeah.
awesome. Yeah, that was really fun. It's funny
Great job.
hearing your lawyer say, don't rely on your lawyer, because it's